7/13/2022, in the Circuit Court of Fairfax County, John C. Depp II, Plaintiff versus Amber Laura Heard, Defendant. Order. This cause came before the court upon Defendant Amber Laura Heard's post-trial motions. After review of defendant's post-trial motions, plaintiff's opposition, and the relevant statutes and case law, it is therefore ordered as follows. Defendant Amber Laura Heard's post-trial motions 1 through 6 are denied for the reasons stated on the record. Defendant Amber Laura Heard's post-trial motion 7 is likewise denied for the reasons outlined below. The purpose of voir dire is to obtain a fair and impartial jury. Voir dire is necessary to ascertain, quote, whether any juror has any interest in the case or any bias or prejudice in relation to it, and that he in fact stands indifferent in the cause, unquote. The summons issued to Juror 15 listed his legal name and address, and no birth date was noted. The court has pulled Juror 15's jury questionnaire, attached as redacted, filed under seal. Juror 15 completed the jury questionnaire as himself, filling in his proper birth date. The information presented on the jury questionnaire matches the information Juror 15 provided to the court. Juror 15 was vetted by the court on the record and met the statutory requirements for service. The parties also questioned the jury panel for a full day and informed the court that the jury panel was acceptable. Therefore, due process was guaranteed and provided to all parties in this litigation. Voir dire was conducted in a fair and impartial manner, with the court and both parties examining the potential jurors. There is no evidence of fraud or wrongdoing. Further, the defendant was provided the jury list 5 days prior to the commencement of trial and knew or should have known about the mistake at any time during the 7-week pendency of this trial. She had every opportunity to object or to voir dire on the issue. Parties generally must make objections at the time a ruling or order is made to put the court on notice that an issue is meant to be preserved. Despite defendant's assertion of footnote 9 of her motion, Virginia Code 8.01353A clearly states, quote, any error in the information shown on such copy of the jury panel shall not be grounds for a mistrial or assignable as error on appeal, and the parties in the case shall be responsible for verifying the accuracy of such information, unquote. Consequently, defendant as well as plaintiff had an affirmative obligation to ensure the accuracy of the information provided for the jury panel. A party cannot wait until receiving an adverse verdict to object for the first time on an issue known since the beginning of trial. The issue has been waived. Even if, arguendo, the objection has not been waived, objections to any alleged discrepancies in jury lists and any legal disabilities of potential jurors must be made in accordance with Virginia Code Section 8.01-352. That section provides, in relevant part, quote, unless objection to such irregularity or disability is made pursuant to subsection A herein, and unless it appears that the irregularity was intentional, or that the irregularity or disability be such as to probably cause injustice in a civil case to the party making the objection, then such irregularity or disability shall not be cause for summoning a new panel or juror, or for setting aside a verdict or granting a new trial, unquote. Virginia Code 8.01-352b. Furthermore, while parties must make this objection while following the above procedure, the party moving under this code section must provide some evidence of prejudice. Defendant has neither followed the proper procedure nor shown evidence of prejudice. Defendant does not allege Juror 15's inclusion on the jury prejudiced her in any way. The juror was vetted, sat for the entire jury, deliberated, and reached a verdict. The only evidence before this court is that the juror and all the jurors followed their oaths, the court instructions, and orders. This court is bound by the competent decision of the jury. This order is final.